Over the years, fewer cases are going to court and alternative dispute resolutions are becoming more and more common. There are two types, mediation and arbitration. Attorney Jim Higgins with the Higgins Firm recently stopped by to explain the differences. Jim, welcome back to the show.
Thank you.
All right, so we know there are two types. So let's just start by talking about alternative dispute resolutions, what they are. What's the definition of that?
Well, it's an alternative to going to court, to actually having a trial in front of a judge or a jury. And I'd say over the past 10 years, it's really kind of exploded in as far as the legal field, the field that we're in.
Yeah.
And it used to be, we'd file a lawsuit, and if we didn't settle it among the lawyers, then we would just in a courtroom, go to courtroom. And now, so many of these cases, we either mediate them, which is where we hire an independent person to come in and they help us resolve the case. I'll be in one room with my client, and other folks will be in the other room with their clients. Mm-hmm. And it really works better than I think people anticipated because, as lawyers, we are always stuck in our corners and we're kind of bred to fight for our clients, and that can make it hard to find middle ground sometimes. So
right.
A good mediator can help us find that middle ground. And the second type is arbitration, and I'm not always as big a fan of arbitration, and that's where instead of going to a judge or a jury, and usually it's contractual, we hire a private person to try our case in front of.
Okay.
And he becomes the arbitrator, and what he or she says, that's the judgment.
So let's talk a little bit about mediation and why somebody would choose that rather than going to trial. Is it solely for the money reasons?
Yes. Well, trials are stressful, right? And they're difficult. And the thing about a trial is that, well, now we have the lotto, but we used to say the only legalized gambling in Tennessee was a trial, because I could try the same case 10 times and that jury is going to give me 10 different verdicts.
Right.
You just never know what people are going to do. And so when you mediate, you've got some control left, right? So you can, I feel like I can give my clients some say-so in their case, try to become to a number, and usually we do this in high-end. We do a lot of high-end kind of personal injury cases, wrongful death cases, nursing home neglect cases. Those are high-pressure cases. They're usually high money number cases. And so to be able to sit in a room and talk it out on what this person needs to help them get through this and get on with their life is a very beneficial thing.
Okay, let's talk about the flip side of that. Why would someone want to go to trial rather than mediation or arbitration?
Yeah, well, sometimes we just don't agree. I'd say a majority of the mediations I resolve, but there are sometimes that we just need that jury, that we value the case at a certain amount. The defense may not value that high, and we say, all right, you know what? Let's let 12 people decide, and that's what it's for.
All right, well, Jim, great advice. Thanks so much.
Thank you.
The Higgins Firm is serving Tennessee. Give them a call at 615-924-8500 or go to higginsfirm.com.